Set over request from Mr. Teft. Let me just go ahead and call that matter. This is Alonza Morris Teft and Michael Teft. It is a review hearing on contempt. I see Ms. Teft present. Mr. Teft, there you are. Are you able to turn on your audio and video? Or at least audio, Mr. Teft, we can't hear you yet.
Can you hear me now?
We can hear you now. Are you with us?
Reception's a little bad. So my video's off today, but my reception's bad.
Okay. I'm just pulling up the notes. I'm
on hold, so I don't know if you want to keep going or should I?
I'm going to just mute folks who are not currently in front of the court. I reviewed the notes when I was out, looks like about 2 weeks ago. A judicial officer filled in and did appoint Mr. Teft an attorney given the jail sanction that's being proposed. Is there an attorney from public defense present in this case? I don't see anyone. Mr. Teft, have you been in contact with an attorney from the public defender's office?
So, yes, I called the clerks to get a hold of an attorney.
Okay.
But there seemed to be confusion. They said that they would not worry about today. For some reason, they did. I don't know if they took note of it or anything, but yeah, currently I don't have an attorney. I've kind of been working through that with the clerk's office.
Okay, so Mr. Teft, I don't see an attorney online for you today. The judicial officer on August 30th had appointed you to an attorney. So what I'm going to recommend instead of calling the clerk's office is that you call the Office of Public Defense directly. That's here, it's the Cowlitz County Office of Public Defense. Ms. Teft, because the judicial officer did assign Mr. Teft an attorney, and that attorney has not appeared today, and I don't see any notice of appearance, I have no choice but to set over the review on contempt until that attorney does appear.
Mr. Teft didn't even call the attorney. Like, he told the guardian of Ada when we had court yesterday that he didn't even contact the attorney. So I don't know why he's lying and saying that he called.
Yeah, and ma'am, all I can tell you is there's no attorney who is online. It's also incumbent upon the attorney to appear. It's not just on Mr. Teft. He has been appointed an attorney. I'm going to set this to Wednesday, September 27 at 9 a.m.
That's also the date because I filed another contempt for this month too.
I see that in your motion in order for show cause. Has that been served on Mr. Teft? I did not see proof of service.
I'm going to turn in the proof of service today. He has been emailed and mailed a copy as well.
Okay, so we'll go ahead and handle both the continued jail time request on the September 27th date when an attorney will be present, hopefully, and we'll also handle your show cause motion, I think, for the month of
September.
Month of August contempt. Yes. So we'll handle both of those matters then on September 27th. I'll have my judicial assistant reach out to the Office of Public Defense as well, just to make sure that they've been notified of this appointment.
Okay. I don't question. Why does he need an attorney if this is self-represented?
So anytime a jail is contemplated as a sanction, so in your motion for contempt, when you request jail and when it is something the court is going to consider because of continued failure to not pay, then the court has to appoint counsel. So anytime jail is a potential sanction, we do have to appoint counsel before the court orders jail.
What does that mean, appoint counsel, just for my own knowledge, just to clarify?
To give him an attorney.
Oh.
He has a right to representation if jail is contemplated.
I get that, but I'm saying what does the attorney gonna do if he's been failing to pay and jails for him not paying?
I can't engage with you on what the attorney may or may not do. All I can tell you is our obligation as judicial officers is to appoint him an attorney when jail is a very real contemplation and a very real potential outcome of our ruling. Okay?
Okay, can I get an attorney too?
Well, jail is not being contemplated for you, so
Okay, so I don't need one.
permission to appoint you an attorney.
Okay.
Okay. Mr. Teff, do you have any questions for the court? Otherwise, we'll see you back on September 27th. I will see what I can do on my end to make sure that Office of Public Defense is aware of this appointment, but please reach out directly to Office of Public Defense, not just the clerk's office, okay?
Yeah, I have a question.
Go ahead.
Yeah, why wasn't I given an attorney earlier than when I was faced with the first order of jail time when I specifically asked for one?
Because we were not contemplating jail time at that time. So just because it's requested does not mean it's a potential ruling that is going to be made. My assumption is when you were in front of the last judicial officer, he was probably leaning towards jail time. And if that is what he was going to rule, he has to give you an attorney first. Okay. All right, we'll see you both back on September 27th.
At 9 a.m.?
At 9 a.m., same docket. You'll use the same. I believe we have Beth
Okay,
Fellows on
Yes,
this
you're welcome.
case.
Yes, Your Honor.
And Ms. Looney, are you on this case as well?
I am, Your Honor.
Okay, great. And then do I have Mr. Weiss?
Yes.
There you are. Okay. And Ms. Shoemate?
I emailed actually both parties, both parents, because they didn't realize that they had court. I just got an email from mom saying that she's at some appointment.
Okay. And I was a little myself confused what we were doing for today's review hearing, other than it might have been set before this case went to trial assignment. So I do see now that the case is on for trial readiness and pre-trial. So yeah, go ahead and let me know if there's something you think we need to do today. Otherwise, I'm kind of inclined simply to strike it.
Well, it was basically to review the GAL report. I have not filed it yet. I plan on filing it by next week. But I do have some questions. Number one is we have a pretrial readiness, pretrial management hearing on the 20th, but it's judicial conference week. So I'm not sure if that's an accurate date.
Yeah, that is going to get moved, I would assume. Is that right? Okay. So the court is asking for us to go ahead and move that now. And I know we don't have Ms. Shoemate here, but we'll go ahead and renote it for the 27th at 9 a.m.
And I do have another question.
Hold on one second. We're just let's get this done for the court. Wednesday, September 27th at 9 a.m. on this docket for pretrial.
Okay.
And then I'll make sure we have someone reach out to Ms. Shoemate to inform her of that change.
Okay.
Okay, go ahead, Ms. Fellows.
Yes, I do. There is another issue that actually the dad had brought to my attention. We are set for a parenting plan modification. However, there's never been a final parenting plan filed and signed. So I think that there was some confusion because this has been such a long-standing case. Mm-hmm. There was a CR2A agreement way back, I believe in 2018, I think, but there was no final parenting plan filed. And then we were back in on September of 2021 is when I was reappointed. Judge Hahn was hearing the case and did grant the GAL recommendations, and a temporary parenting plan was put into place in December of 2021. So there's never been a final parenting plan. It's only been that temporary parenting plan. And so I'm not sure if what we need to do to make sure that this upcoming trial is named correctly, if that makes sense.
Yeah. What? Hold on, I'm just going back to 2021 here quickly. Lots of orders on contempt in between, lots of motions, adjusting visitation, just as bench orders.
I believe it was December 6th, I think, of 2021, where we had court. Judge Hahn made the orders. And I believe it was December 21st, where Judge Basher signed the presented orders for the temporary parenting plan.
Yeah, I see the temporary parenting plan. So I think what I want to do, because Ms. Shumate isn't here, I don't want to get too far down the road of making decisions on this, but I think that we should list that clarification of the trial issue when we are together on September 27th. My gut is that this would then be, rather than any sort of modification, what we're looking at is permanent orders, is what the parties would be presenting. And I think we previously discussed how we did not believe, we did sign the order waiving mandatory mediation. But yeah, I think you're absolutely right on that, Ms. Fellows, is that we wouldn't be calling this a modification trial. This really would be a final orders trial.
Correct. And so I'm not sure if we have to go through the whole trial assignment process again, or if the court can, when we come back on the 27th, talk to the party and then basically just rename it.
Yeah, I think that makes a lot of sense to me. I'll put a note for myself on the 27th, assuming the parties are in agreement with that and the parties go into trial. It's set for one day, so still plenty of time to address that issue. So let's confirm that on the 27th. If for some reason there's disagreement once Ms. Shumate is online, we certainly can put it back on trial assignment and get a different date. But for purposes of your report, Ms. Fellows, I think it makes a lot of sense to focus on the final parenting plan versus any sort of modification.
Yes.
So I appreciate you bringing that up. Ms. Looney, any input from the state at this point?
No, Your Honor, my only question was regarding that pretrial hearing, so we're good.
Okay. All right. Mr. Weiss, we'll see you back on September 27th. We'll do the pretrial conference and try and clarify the issue for both parties before you proceed to trial, okay?
Sounds good.
Oops, I couldn't hear you.
Sounds good to me.
Okay. All right. Thank you all. Get into that
Thank you, Your
docket
Honor.
quickly. Thank you. I see Mr. Hanson present. Do I have Kimberly Hanson?
Yes, I'm here.
There you are. Okay, great. Okay, well, we've been here a few times, sometimes with me, sometimes with a different judicial officer. We are still looking at that primarily past due spousal support. When you were back in front of Judge Basher on August 30th, it sounded like, Mr. Hanson, you were going to be making a payment on Friday, and you were still talking about the retroactive funds based on some work issues. What can you tell me at this time? Mr. Hanson? Mr. Hanson, can you hear the court? Okay. So on this case, what I was saying previously is I had signed an order on contempt back in July for past spousal support. You've had 2 review hearings, one with me and one with a different judicial officer, and we're still kind of waiting on status of that retroactive payment. So what can you tell us?
I just received our retro schedule from our recently approved contract. On October 2nd, I will be getting a retro check that will cover the raise on the contract from July 22 to July 23. And then on Friday, November 3rd, I will be getting a retro check to cover July of 23 through the previous date now. So that will be enough to cover the $5,000 that I'm back on. I made August payment and I made September payment, and I can make October payment prior to the retro check, or I can cover everything when I get that check.
Ms. Hanson, let me turn it over to you to ask how you would like to proceed. This isn't quite what I was hoping for today, but this is your life and your case. So are you wait to see if those payments come in October 2 and November 3, or what is your request of the court?
I would rather have it paid before those dates. I keep hearing about all these things that trips he's taking and a new boat, and it's hard when I've had to take on a part-time job to try and pay my bill. So I would rather that be paid before that. And it's also 5 months, not 4 months of back pay. It's March through July. So it's $6,250.
Yeah. So the original, when you filed the original contempt order, you filled in March to June,
Right.
for $5,000. So are you indicating there's now an extra month, June to July?
Yeah.
Okay. So why don't you, let me make sure I don't think I have anything new from you for that extra month. I'll just double check my orders here. No, I don't. So,
When I it was June, and so I couldn't really, because I hadn't seen if he was going to come through, and he didn't.
Right.
He's in August.
Yep. So we've got the $5,000 order. If there's the June to July for another $1,000 that has not paid, please file a new contempt hearing order for the extra $1,000. We'll review that when we're back together on this case. I will very much be entertaining interest on these payments because, Mr. Hanson, I do feel as though we're getting a little bit of runaround from you about getting this retroactive money paid. This has been requested and ordered of for many, many, many months. And every time we're together, you tell us that, oh, next week or the next week or the next week. And that I can understand Ms. Hanson's frustration. So I will give you a new date, but it will include additional interest on this money because it is not fair that she's had to wait this long for it.
Is there any way I can give you my work schedule? I didn't work last week. I'm on a job today that I had to replace on because you have to replace or show up. The week before I had a 2-day job. I'm not getting a check this week. I'll get a check next week. How can I send you evidence showing that work is very slow? Is there a way I can send that to the Superior Court to show you that I'm not working?
Well, sir, so a couple things, and I understand that handling these cases without an attorney can be difficult, but all I can go on is your decree of dissolution and what was ordered that you pay. So if you believe that you can no longer pay that money, you could file certain requests in this court to reduce those payments. But what I am currently working off of is the court's requirement and order that you pay that amount of money every single month. So I can only look at, have you paid it or have you not paid it?
Right. Not the reason. You can't look at the reason I haven't paid it.
No, I have an order signed by a judge in this county saying he has to pay this money, and you have not applied. You have not applied for any excuse for making those payments. You have not applied for any modification for making those payments. You just come here and tell us you're going to pay them, and then it still doesn't happen. So I will do a last set over on this to, you said on October 2nd, you're getting retroactive money?
That's correct.
Okay. I'll set this to October 4. That docket's open, correct?
Yes.
That's going to be October 4 at 9 a.m. Couple things I want to see. I want to see that a significant, if not all, of the retroactive money has been paid. Ms. Hanson, also, before that time, please file with the court and on Mr. Hanson your request for the additional month, the June to July contempt period. Okay. Leave open the interest on that amount. I will be awarding interest based on how long this has taken, and we'll reassess this case on the 4th. Okay.
Okay.
Any questions for me?
So when does contempt come into play? Like you just wait and wait and wait and
He's already in contempt, but the only other thing I can do is throw him into jail. And right now that's not going to help you get your money when he's
Right.
working and expecting these checks. So unfortunately, as he probably heard me tell someone else, if we get to October 4th and those retro monies aren't paid, then I probably will be appointing a lawyer to you and we will be contemplating jail, and that helps no one. But that's the last tool we have in our toolbox. So
Right.
I'm really imploring you, Mr. Hansen, this is important. These are court orders. This is important to Mrs. Hansen. My hands are tied when a judge tells you you need to do something and then you fail to do it, or you fail to file a motion stating why you can't do it. Okay, so we'll see you back on October 4th.
Good morning, Your Honor.
Thank you. And it's Stephanie
All right.
Jones. Okay.
Thank you so much. That's correct.
And then just to make sure, I think we clarified this last time, but you haven't had a GAL, Ms. Larson, involved in this case in some time, correct?
Correct. The second GAL was appointed, but never fulfilled because there wasn't one available at the time. But a second one has been ordered.
Okay. Let me just jump into your digital file here. I did, since we were last together, I did get the updated guardian ad litem, or excuse me, the sealed confidential reports from the reunification counseling. So that is good. Have you seen those, Ms. Jones?
The only thing that I received was a letter from Ms. Brandhorst.
Yeah, I got that. It looks like September 8. It's dated September 8. Is that the same letter you got?
I received it Monday, I believe so.
Okay. Just looking to see here who I don't have notice of a new GAL.
It was Judge Fetter that ordered that.
Okay. You have, last time he was on your case, I'm just not seeing it in here. Do you have a date or about how long ago he ordered that?
I would have to look, Your Honor. It's probably been 2 years.
Oh, okay. Okay.
Yeah, it was a significant amount of time.
Go. So here's what I will talk to the parties about. So we're technically here for a review hearing just to make sure we have the reunification counseling notes, which we do. It sounds like the reunification counselor is recommending that we begin unsupervised visitation at this time. Have you had a chance to review that recommendation, Ms. Jones, and do you have any position on that?
Yes, it was my understanding, Your Honor, that supervised visitation has already been ordered after reunification counseling.
So this is so the recommendations in this most recent letter are for unsupervised visits with RLL for 2 to 3 hours weekly, and then to continue reunification counseling 2 times a month.
Mm-hmm. Yes, I understand. It was just my understanding that it has already been ordered that once visitation started, it would be supervised.
Right, that's great. That's not what I'm asking you though. So what I'm looking at is today's recommendation that's in front of me. So today's recommendation in front of me from the professional who's engaging in reunification counseling is that we allow unsupervised visitation 2 to 3 hours weekly. So I'm asking whether you're objecting to that.
My position would be that I would prefer that it start as supervised.
Mr. Lakey, what is your position?
I thought that's what I was having with the reunification counselor was supervised visitation. That was considered visitation. And it has been going well. And especially the last at least 3 visits or so, it's been really a lot better.
Mm-hmm. Are you requesting at this time to have unsupervised visitation?
If that's what Barbara recommends, yes, I would like that.
So what I'm going to say, I know I am leaning towards agreeing with the professionals who are recommending unsupervised visitation. What I'm going to do, because I think there's also simultaneous DV counseling still occurring, is that right?
Yes.
Yes.
And that has not concluded, correct?
No, I think I have 8 weeks, I think I have left.
Okay. What I'd like to do, because I think one of my concerns is just making sure that the reunification counselor and the DV counselor are both on board with the same recommendation that it is safe to go to unsupervised visitation. My preference would be to appoint a guardian ad litem back on the case who can receive both of those expert reports and make a recommendation to the court. Do either of you object to a GAL being appointed?
Well, right
I
now,
do not.
Okay.
well, right now with me doing my DV assessment and doing reunification counseling, it's, fairly expensive right now.
Yeah, and we'll take that into account. I do think in child's best interest, though, we do need a new GAL since it's been over 2 years. And I want to make sure the experts are talking to each other and then the court is getting one unified recommendation. So until we get that, I want Mr. Lakey, you're doing a great job based on all reports from unification counseling. Sounds like it was a rough start, but you're doing really well. So please, keep it up, keep that supervised visitation going with your child. We'll get a GAL appointed. I'll give you some names here in a minute. And then we'll talk about income to see who pays for that. Okay.
Okay. Did you also receive my compliance reports as well?
From reunification?
No, from my DV.
Yes, I do. Yep.
Okay.
And I show no absences. You've attended for the month of August. You attended all of your appointments. Pretty high scores for ranking, mostly consistent rankings for a lot of taking responsibility actions. It looks like there's some areas of improvement, but I think if they gave everyone 5s, there would be nothing left for you to do in the program. But it looks like you're doing fair to very well, at least according to your August report. Okay.
Okay.
Okay. What are the next 3 GAL names? So we have Amy Turnbull, Ann Height, or Twyla Corey. Any objection to those names?
None for me, Your Honor.
And what was the second one? Amy Trumbull and
Let's see. Amy Turnbull is the first one. So she would be the first one I would appoint unless there's an objection. The second one is Ann Height. And the third one is Twyla Corey. And you all had Rhonda Larson last time. So these are all 3 different names.
okay. I have the only one that I think was proposed was Twyla before, and I didn't.
Correct.
So the other 2, I don't have any idea who they are. So
Okay. So let's go ahead and appoint Amy Turnbull.
okay.
Because I am doing this on the court's motion, I will take that into account here. Ms. Jones, what are you on any sort of state or federal assistance?
No, I'm not.
Okay. Do you work full time?
Yes, I do.
Okay. What's approximately your monthly take home pay and how many dependents do you support on that?
My approximate take home pay is around $4,000. And I support probably 2 dependents.
2 dependents.
Our son just turned 18, so that's why I say 2, because he's not working or anything.
Okay. And Mr. Lakey, what is your income? Are you on any sort of state or federal assistance?
No.
Okay,
I think it's right around 47.
47?
Somewhere in there.
Okay. And then I know you have these evaluations to pay for. About how much is that taking per month?
Right now it's about 240.
Okay. And then how many dependents do you support?
I support 2.
2.
The 2 dependents he's referencing are his girlfriend and her daughter, and she receives child support for that child.
Okay. Yeah. And I mean, regardless, you both are fairly well above poverty guidelines for any sort of county pay. So your incomes are fairly close. My recommendation would be a 50-50 split on the GAL costs. Are you in agreement with that?
Okay.
No, Your Honor, I'm not. Mr. Lakey does not pay child support and has not paid child support for 5 years. He has a significant way to pay his 60% that's ordered by the child support worksheet.
Okay. Well, for this purpose, and because we are court ordering the other evaluations, which are about $260 to $270 a month, I am going to go ahead and do a 50-50 split on the GAL fees at this time. I will add a notation that should that prove burdensome to you, Ms. Jones, you can ask that to be revisited by the court at our next hearing.
Ms. Lumpkin only receives $20 a month from the person that for child support.
Okay. So what I want to do is get the GAL involved. I'm not going to change visitation at this time. I want to set a new review date. I want to keep getting the reunification reports and the DV reports. And then I'll have Ms. Turnbull actually put both of those expert recommendations together into a recommendation for the court on how visitation goes forward. I think that she's going to need at least 30 days, which probably fits when we would get you back in here anyway. So does Wednesday, October 11th at 9 a.m. work for you?
Yes, that works for me.
Okay. And Mr. Lakey, does that work for you?
Yeah.
Okay.
October 11th.
Yep.
That week. Okay.
Okay. I'll get the order appointing Ms. Turnbull. We'll get that information out to her. Okay. Thank you both. We'll see you back on October 11th. I appreciate both you being here.
Thank you.
Thank you. Have a good day.
Good morning, Mr. Lawrence.
Morning.
Let's see. Do we have Elisa Gutierrez? We have Francisco Gutierrez, I see. Mr. Gutierrez, are you able to unmute?
I think so. Can you hear me?
Sorry, I was taking a sip of my coffee. I can hear you, sir. So we do not appear to have the petitioner present. I'm just checking our waiting room. I don't see anyone in there. When I reviewed this file, I was looking for the evaluations to come in. I don't see that, so I'm not sure what we would do today anyway, but Mr. Lawrence, any input that you have?
The court had asked me to assist Mr. Gutierrez in finding a provider. He has Kaiser insurance through his employment. He had formerly been in outpatient drug and alcohol treatment through Kaiser. And so he should know how to go ahead and sign up again. Mr. Gutierrez did try to reach me about a month ago. He left a voicemail and an email. I responded to him through a voicemail and an email indicating a couple of dates that I would be available to speak with him. And I heard nothing back. So that's where we're at, Your Honor.
Okay. And I don't have the petitioner here, so in all likelihood, we'll simply be setting a new date. But Mr. Gutierrez, have you started the evaluation process?
Yeah, I did. I guess I need to get in touch with the counselor I spoke to because she was supposed to send a mail to Mr. Lawrence and also to Elisa.
Okay. When, where are you engaged in, where did you do the evaluation?
I did it over the phone through my health insurance, through Kaiser.
Sir, I can't hear you. You're going to have to speak up.
Give me 1 second.
Okay.
I did it through Kaiser, through my health insurance.
Okay. And are they recommending treatment? Are you engaged in treatment?
No.
Okay.
She even had me do the very next day after we spoke, she had me do a drug test, which I did. And that was supposed to be part of the paperwork that it should have been mailed to Lawrence and Elisa as well.
Yeah. So here's my thought, especially since Ms. Gutierrez isn't here. Let's do that over. And what I want you to do, Mr. Gutierrez, is make sure rather than, I'll tell you sometimes with Kaiser, you can't rely on them sending the documents out. You have to actually go get them. And then you yourself would get them to Mr. Lawrence and or the court, filing them under seal. So I'm going to give you a new date. I want to have that evaluation to review at the next date. I want Ms. Gutierrez to be here for that date. What date do you want, Mr. Gutierrez, you think that you could go get the reports, get it to the parties, get it to the court, and come back here?
I can work on that today. I don't really have a set date. I mean, you can give me date, whatever day you like.
Well, I'm guessing you want it sooner than later because that determines whether we can reinstitute visitation for you. So I assume you want it sooner than later.
Yeah.
Okay. So I could offer you Wednesday, the 27th, which is in 2 weeks, or we could go 3
Okay.
weeks out to Wednesday, the 4th.
No, Wednesday the 27th should work.
Okay. Mr. Lawrence, does that date work for you?
The date works for me, Your Honor. The question is whether or not, if we get the documentation from Julian for Kaiser to provide input, how long it's going to take for them to actually incorporate our information with their findings. I guess I would suggest that we move it out to 3-week date to give us a little more time.
Okay. I think that makes a lot of reasonable sense. So let's go ahead and set this to October 4. So 3 weeks out at 9 a.m. The hope there, Mr. Gutierrez, is that we won't have to do any further set outs because that'll give all the parties and experts in the case time to get their stuff together, get it to Mr. Lawrence to make a recommendation to the court. Also, I will need to have Ms. Gutierrez present on that date. So we'll have to get notice of this hearing out to her. Okay. Okay. Anything else on this matter?
I just like to say something. My income has changed. My income has changed to where basically I have no income. Is there any way I could get that fixed?
So I can't give you legal advice, but I can say, are you talking about child support payments?
Yeah.
Okay. I can't give you legal advice. What I can recommend that you do if you have a question about whether child support can be modified is to have you reach out to either a family law attorney or a legal aid clinic that might be able to provide you free or low cost advice on that sort of issue.
Okay.
Okay.
All right.
All right. Thank you for your question, and you are free to log off. Mr. Lawrence, anything further?
No, Your Honor.
Okay. Thank you for your time. Okay.
Thank you.
Let me just go into your file. Do you see Michelle online, sir?
Excuse me?
Do you see Michelle online? I'm not, no one's responding to that name.
I'm sitting outside of your courtroom actually right now.
No, I mean, in the
But
Zoom.
no, I don't see her, no.
Okay.
And Your Honor, there's some things that have changed, and so as of today, she has relinquished custody of 2 of our 3 kids to me. And so I don't know how that affects today, or we have to get a new parenting plan.
Well, yeah, and here's my thought. I also had questions about what was actually properly served on her for today anyway. Because I don't see a proof of service on your motion for contempt on
Right.
her. Did you serve that on her?
I thought the courts were doing this. I have no idea, Your Honor. I came here 3 weeks ago and filed a contempt of court.
Right.
Because I wasn't relinquishing the children as our planned parenting. But since then, she has given up her parental rights.
Okay. Okay. So based on your statements today, her lack of appearance coupled with the fact that I'm going to find that your contempt order to be heard today was not served on her based on what you're telling me. So it's incumbent upon you to serve her after you file it with the court. The court doesn't serve her with it.
Oh.
Yeah. So that's why she's not here. So what we're going to do, and I get it, when people aren't represented by lawyers, this, the getting through the judicial system is very difficult. So what we're going to do is just strike your motion for contempt today, because it sounds like, number one, it wasn't served, and number two, it might be moot because of this relinquishment issue. So
Right.
I'm going to strike the contempt on my docket today.
Okay.
What I'm going to recommend then is if you have a new type of motion or a new type of parenting plan you're going to request, go ahead and prepare that and refile it and note it on any Wednesday morning docket.
Okay.
Okay.
Okay. And then, Your Honor, So I'm just at a loss of words.
Go ahead.
Yeah.
We're not denying any of your requests today. It's
Oregon over in Astoria. So I've taken off work because I didn't know that we could Zoom either.
Yep.
At the same time, she filed our parenting and stuff when we got her divorce here in Longview because this is where she resides now. Can I file in Astoria a parenting plan?
that would be legal advice that I can't give you. Also, she's not here, so I have to be very careful about what we talk about with this case. So all I can say today, and I'm not trying to be obstructionist, I just have to maintain my role in the judicial system. So what I can tell you today is I'm going to strike your motion. It's not a denial. It's just a, hey, it wasn't served. And circumstances may have changed and she is not here. We're striking your motion. If you want to refile, maybe seek counsel before you refile to decide if you want to file it here or in Astoria and what's the proper venue. Okay.
Right.
And like I told the last party, sometimes local legal aid clinics can provide that kind of advice free or low cost.
Okay.
Okay.
All right.
All right.
Thank you.
Yep. Thanks for
know.
logging in. Yeah, and if you do come back to this court, you can log in from your home or office at Zoom. You don't have to come here for it. Okay.
Have a wonderful week. I don't know how to turn this off though. I don't know if they
Just go ahead and mute it and they'll take care of it when you leave.
I did mute it earlier, but it wouldn't. I hit my face on the little square button, but it doesn't do anything. I don't know. All right, Your Honor. Thank you.
I have temporary orders that have been filed by Ms. Gibson. I don't know, Mr. Visick, have you received these orders?
Yes, I have, Your Honor.
Okay.
Your Honor, I do want to just say, due to some medical issues over the last week, I was unable to get my evidence served to Zach Bissig that I had filed with the court. I ended up in the hospital with a concussion and a bruised tailbone and have been on bed rest since.
Okay. And that was some of the documents that you filed in support of your temporary orders?
Yes, they were my evidence for why I feel the temporary order I had submitted to you guys was necessary.
Okay. Mr. Visick, my understanding is you have filed your own temporary orders and proposed parenting plan in this case.
Yes, Your Honor, I have served her already.
I saw that you had served her. I think the concern when you all were in front of the last judicial officer was proper service. And it looks like we still might have an issue, Mr. Visick, of you being properly served with all of the documents that the court would be relying upon today. So let me ask you, Ms. Gibson, when do you believe you would be able to get that served on Mr. Visick?
Honestly, Your Honor, at this point, I would like to just move forward and strike out my evidence and go off of, I did prepare a statement if I'm allowed to read it, and just kind of just go forward. My head is throbbing due to my concussion, and I don't know when I'm going to be better, let alone filling up for everything. So I would like to just move forward.
Right. So I wouldn't be allowing you that kind of testimonial statement. Again, we're without Mr. Visick being given a heads up on what that is. That's why we require these to be done with declarations. We don't do trial by surprise here. So if you are saying that there is something that you are going to rely upon in this hearing for temporary orders, I do need to have you serve it on him. We could ask Mr. Biscuit, excuse me, my mouth is dry. I need to stop drinking coffee and move over to water. If you would be willing to accept service of that by email, we could probably get that done much quicker than if it's personal service. I don't know if that appeals to the parties in any way or is acceptable to you, sir.
Not really, because I do know for a fact she was at the bar last Saturday. So I think she had plenty of time to do it, and she's just making excuses now. And it's already been a while, and I really want to see my kids and get this going.
Well, I understand, but I'm telling you that she, whatever the reason, she has documents that she is going to serve on you. Would you agree to have those served by email, or would you like those to be served on you personally before we move forward? If she does it by email, we can get you back on the docket much quicker.
How much further would it be if she actually personally has to do it?
Well, it depends how long it takes to find you and personally serve you.
I'll just take the email.
Sorry, I couldn't hear you.
I'll just take the email, Your Honor.
The email. Ms. Gibson, are these documents that you can serve by email?
Yes, one of them is a statement, and then I have all the pictures that I had submitted to the court already on my computer that I can email to him as well.
Okay. Please get those emailed this week so that he can file any objection or response to that evidence. And then I'm going to set you to the September 27th, 9 a.m. docket.
All right. And then for the statement, it's not something that I had submitted to the court. I would need to get that also submitted to the court along with my proof of service.
Yeah, you would want to do it as a declaration. Yes.
All right. Just want to make sure. Thank you so much, Your Honor.
Yes. And then you both can log in via Zoom. I'll keep your temporary orders here that you've both proposed, and we'll see you back on September 27th at 9 a.m. So, okay. It sounds like, all right. Thank you both. Y'all have been here many times. What it looks like I just was handed this morning is a declaration of Anna Manley that was filed with the court yesterday. And it states that Mr. Fike had filed some additional documents on her on perhaps September 11th, which would have been Monday. So let me first ask, Mr. Fike, have you received the September 12th declaration from Anna Manley?
Yeah, I received that last night, Your Honor. And what she's referring to is what I filed the previous week. I believe it was Wednesday or Thursday is when I filed it in the court. And it was just 2 declarations and some text messages. And she's saying that she didn't receive the text messages. Well, she actually filed those same text messages herself. So I didn't feel the need to give her the same. It costs, about $30 for a cartridge of ink. And I've gone through 4 of them in this whole process so far. So she knows what text messages they are. It was filed last week. I turned in the form on the 11th of proof of service, I believe it was.
So Ms. Manley, the document that he said you served on September 11th, that you were served with on September 11th, that he filed September 6th, did that contain new information that you were not previously aware of in any way?
No, but it also said that in his declaration that he filed with a letter from a dentist. I also never received that. And I never received the text messages he filed either.
So you don't have the letter from the dentist?
I do not.
I also just want to ask Mr. Fike, it sounds like you have a phone conference with one of the doctors today.
That is correct, with social services as well.
Okay.
At the request of her doctor.
Yeah. Is it your understanding that you may be providing additional evidence depending on the outcome of that meeting with the doctor?
I would assume so. I'm not really sure what it's about, Your Honor, and I can explain that a little bit.
Go ahead.
On August 31st, I received a phone call from Kaiser. It was the same lady that does the appointments for Kaiser. She told me that Anna had called her and demanded a call back from them. And she called me because I was the first number that was on there and wanted to know what it could possibly be about. I told her that it was probably for the immunizations that Liliana is due for. And I assumed she was making an appointment for that, considering that's what appointment that section is for at Kaiser. Well, about a few minutes later, the same lady from Kaiser called me back and said that after that conversation, the doctor would like to set up a meeting with myself and social services about what is going on in the mother's home. There was no explanation of exactly why. The only reason it's today is because that's the first time that we could get in for an appointment. In her declaration from last night that I read, she said that she spoke to the doctor yesterday, which I know that's not possible because you can't just call a doctor's office and talk to the doctor. You have to make an appointment with them, especially at Kaiser. They're a very busy doctor's office.
Okay.
So that was a little confusing.
Yeah. Well, here's my take on this. We've got some very late filed declarations. But the reason that I want to set this to a new date is not to delay this in any way, but because I believe that your conversation directly with the doctor today may provide pertinent information that actually advises this court. I feel like right now I'm getting a lot of filings just from the two of you that are a little bit, he said, she said. My hope is that out of this conversation directly with the doctor, that perhaps something from the medical professional could be provided directly to this court that gives the court some clarity on what is happening in this case, so that I have some more objective grounds with which to decide these contempt hearings. So what I would be asking Mr. Feig, I think in the benefit of your motions and Ms. Manley to the benefit of your motions, is that you hold that conference with the doctor and we renote this for our next family law docket, which since we don't have it next week, which would be September 27th at 9 a.m. And then please file whatever you get from the doctor out of today's conference.
Okay, so all of the stuff that I filed last month after our first court date, has that been looked at?
It is all, I have all three of the motions. We have your show cause, her show cause, and the adequate cause. So we have all of it.
Right. So mine was, the contempt was you dismissed my contempt.
Correct.
But
your first one.
Right. And so the other one that I had and I filed with that was the neglect out of the mother's home. And I filed lots of doctors' documentation from child and adolescent clinic showing that my daughter was being neglected for more than a year with dates and everything on it. And also that she had not been seen by a doctor in over a year and a half and longer than that from being taken by her mother. And all of this is very alarming. I constantly get my daughter with rashes and it's all to the point of
Mr. Feig, I'm trying to help you here because we did talk about this. When you had a GAL involved in your case, there were very similar allegations that were ultimately deemed unfounded from both sides. What I am asking for, and so what I'm telling you without trying to give you legal advice is, right now still, there's a lot of self-serving statements being made by both parties about what is happening with child. Because you have this great opportunity to speak firsthand with the doctor and social services, I would like to hold off on a ruling until I know what their opinion is on child's welfare and safety. And I think that's in child's best interest. And I think it's in the best interest of both of your motions. So that is why I'm saying your prior motions are not, or your prior filings are not being disregarded. I am asking for additional input from these experts before I make my ruling. Okay.
Yeah, I understand that. What I'm trying to get at was with those filings that I put in before, it shows the neglect from the doctor. All those, so
I understand that's your opinion of what it shows. So what we're going to do when we come back on September 27th is we will hope to have additional information, current information from the doctor now that the doctor has spoken to both of you, which I think is very helpful, and with social services involved. And then please get that filed with the court, whatever the outcome of that may be. We will push this to September 27th and we will do the contempt hearing and the adequate cause hearing at that time with that additional information. If we don't have it, hey, at least we gave you all a shot to get it. We'll still move forward. I'm not going to bump you out again, but I would like to have the opportunity to receive that input directly from the doctor.
Okay.
Okay. So does Wednesday, September 27th at 9 a.m. work for the two of you?
That's fine with me.
Okay. I appreciate you getting that conference scheduled. I think it will be helpful. what I would like to do is state, no additional filings except for what may come out of that conference, just because I don't want to be in a position on the 27th of these filings being made 1 or 2 days before the hearing, and then someone asking for more time. So the only filings I would expect before the 27th are documents that come out of today's meeting with social services and the child's doctor.
Yes, I will make sure those are filed tomorrow.
Okay, great. I appreciate you guys working on this, and we'll see you back here in 2 weeks.
All right. Thank you.
Right. Thank you.
Thank you.
Thank you.
That's our daughter, but yes, she's here.
Say that again.
That's our daughter, but yes, she's here.
Okay. Is she able to come onto the camera?
Yes.
Your Honor, I just had one question. Why would my daughter have to be on the camera?
Maybe I am confused about the party in this case. Did she say?
I think you are. Ivory is 2 years old almost, not even.
They have Ivory listed as the petitioner in this case.
Okay,
so
no.
I think it's just my docket is wrong. So no, we do not need Ivory on camera.
Thank you.
We need the petitioner on camera. Is that Monet?
Yes.
Yes.
Thank you. They have you both listed as the respondents jointly, and Ivory is the petitioner. So.
Okay, yeah, the petitioner should be the state of Washington.
Yep. We do not need you on, we do not need your daughter on camera. Okay.
Thank you, Your Honor.
Yeah, thanks for clarifying that for me.
Absolutely.
So let me just jump into your digital file here. Do you still have a GAL involved, Ms. Gravina?
We do not.
Okay. They have her still listed on my docket also. Okay. What I have, and I just want to make sure, there was some issue with service. Have both of you now received each party's contempt motion?
I have not received anything other than the top copy.
Okay. So you received the motion, which states the basis for the contempt?
No.
Okay.
The only copy I have received was order to contempt for court or something similar to that.
The order to show cause for contempt.
Yeah.
Okay. Yeah. So you don't have the declaration.
I have nothing else.
Okay. So Ms. Marquez, have you received the motion for contempt filed by Mr. Sekni?
I have.
Okay. And you have the details in there?
Yes.
Okay. So you have to file on him similarly with the details of your request for contempt. What can you tell me about that?
I believe that I had a declaration and maybe a few copies of some paperwork involving childcare in my schedule. I printed those with the order to show cause and served them on his partner, actually, not him directly, because she was of age and she lives in the home with him.
I'm just looking to see if I have that. I have your declaration affidavit, but I'm not showing it served on anyone.
Yeah, we got nothing other than the top copy at the courthouse. We only got the top copy. That was all that we had received. And it was from the grandma.
Right. Yeah, I'm not able to see that Mr. Sekni has no proper notice of your motion for contempt.
Yeah, I read that and the contempt that they served me with as well.
Mm-hmm. So I can offer you the opportunity, a little more time to actually get that served on him, and we can come back and address it.
Is there any possible way that I could get it approved to send it maybe through the documents that are required, at least through an email or through mail, because he's currently not showing up to parent pickups, and every attempt that I've had to serve him prior to this, he doesn't answer, he's not home, or
yeah. So Mr. Sekni, would you, just for purposes of this order, would you be in agreement to receive it via email or mail?
Yeah, you can send it via email. That's fine. But for anything further, I'd like it to just be, personal service.
Yeah, absolutely. Ms. Marquez, do you have his email address?
I think the one that I have on file is his.
Yeah, that's correct.
That is accurate, Mr. Sekni?
That is correct, Your Honor.
Okay. Let's do that. Let's get him served by email. I will approve that orally by email for purposes of just this motion. I want to be very clear on that. How quickly, I'm going to keep these consolidated into one hearing for judicial economy. If we stay on this unrepresented docket A, the next date I can give you is September 27.
That should be fine for me.
Is that okay for you, Mr. Sekni?
I work, unfortunately. I'm right now. I'm on a break.
Okay.
From work, and so I don't know.
If we set it out another week, does that give you a little time to work your schedule?
Yeah, that probably could.
Okay, let's do, and that is a shorter docket for now anyway. So let's do Wednesday, October 4th.
Okay.
Okay.
And then if there's any additional declaration or evidence that needs to go further into this, can it still be submitted within this 3-week parameter?
It can still be submitted if it supports your original motion, but let's just do a cutoff of Wednesday, the 27th.
Okay.
That way we don't end up in this situation where we have to move a hearing because people haven't been served. Okay.
Okay. Thank you very much, Your Honor.
You're welcome. We'll see you back October 4 at 9 a.m. Let me first ask the parties, are you both seeking to move forward on this? Has there been any change in circumstances since we were all last together on August 23rd?
I'm ready to move forward, Your Honor.
I'm ready to move forward as well, Your Honor.
So what I'm first going to do is go back to our August 23rd hearing. At that time, the first thing we'll address is the child support payments. They had been ordered since June. There was some indication that Mr. Kamba was in contact with child support and they were going to be taking some arrears, as well as making the original payment. So we reserved ruling to see what we could find out about child support payments. What do we know?
Dennis, our child support person, sent me a new table or whatever you want to call it, saying how much Mr. Kamba is behind. He still has not made a payment.
Mr. Kamba, what can you tell me about your child support payments?
I was emailed on Monday by Dennis, my child support agent, saying that a payment was processed, but the payments that have been taken out of my check prior to this process payment still was not sent through. So I contacted my attorney, or not my attorney, my employer, and they said that those other payments were processed on Monday, that they're moving forward.
And Ms. Kamba, you're saying you haven't received any of those payments?
No, and I got my statement from Dennis on the 6th of September, and it didn't show that he had paid anything, and my account that we have set up still has nothing in it.
I am seeing here an email with the support enforcement officer discussing a mistake with a missing payment and that they were going to get a hold of the payroll.
It's muted. I can't hear anything.
Oh, Mr. Kamba, can you hear me? Mr. Kamba, can you hear the court?
What's going on? I can't.
Okay. So I understand Ms. Kamba's frustration because she's just not seeing the money. I do at least have an email from Dennis at DSHS stating that they're working on figuring out what is wrong with the payments and that they contacted the payroll department on 9/5. Do you have an update since September 5 on those payments?
Yes, I actually tried to serve or had somebody try to serve Desiree with the new papers and and on the 10th, on the 11th, multiple times just to get her the information, but she did not answer the door.
Okay, but so what, because I don't have those papers, what new papers do you mean?
So what was the question again? I'm sorry.
So the question was, what you have given me is an email from September 5th saying DSHS was going to look into why the payments weren't going through to Ms. Kamba. So from payroll. So what's happened since then?
Well, I got that email on Monday from Dennis, and one payment has gone through of the amount of $225, which is supposed to be the payment for the whole month.
Yeah.
But since talking to my employer, they've been taking the full month payment every paycheck. So instead of paying $225 a month, they've been taking out $450 out of my paychecks a month.
Right. And so, and Ms. Kamba, you're not receiving any of this, is that right?
Right. And I've been in contact with Dennis, who sent me an email on the 6th saying that we have $0 showing in even his account.
So here's the hard place I'm in. Mr. Kamba did provide his payroll stub that shows year to date garnishment for child support of $675 and a current garnishment of $225, which would track with what's supposed to be happening. So I think at this time, the best I can do is have you all spend another week working with DSHS to figure out why is the money leaving garnishment like it's supposed to. So Mr. Kamba's employer is doing the right thing, but why is it not getting to Ms. Kamba? So I think under these facts, I'm going to continue to reserve on the contempt because I have enough in front of me by way of the payroll records that shows Mr. Kamba's employer is withholding. So now it's just, why are you not getting it?
Okay.
So I'd like to still continue to monitor that issue, but it probably is going to take some frustrating phone calls to DSHS to figure out why you're not getting the money, because it is being withheld from his checks. Okay. And then let's talk briefly about Mr. Kamba, your motion for contempt against Ms. Kamba for visitation. Is that something that you want to move forward on?
Yes, please, Your Honor.
So my understanding is your motion for contempt is that on July 18, Desiree did not take Gabriel on the scheduled visit. Then on August 1st, the scheduled visit was shortened. And then on August 8th, there was a missed scheduled visit. I do have a response from you, Ms. Canberra, stating that you fully admit that you missed a visit on July 18th. You misunderstood the game plan that was going. Because of this child support issue, you've had to get a second job, so you have less free time. The week of August 18 was missed due to Gabriel starting school on August 16th. And by that time, there wasn't time to change your work schedule. Since then, you guys have figured out a time and date, and now appears to have this visitation worked out. Does that sound correct to both of you?
No, Your Honor.
Okay, let me ask Ms. Kamba, is that correct based on your understanding?
Yeah, I've made it to all the appointments that the Reconnecting Families has scheduled now.
Okay. Mr. Kamba, what's your take on that? Do you not believe that this issue has gotten resolved?
No, Your Honor. So when I started my job, I was supposed to be working, the hours that I was scheduled for, with Desiree providing only a certain amount of hours, or that I'm able to see my son on Sundays. I was supposed to work during that time. And with that being said, Desiree she was supposed to provide a list of people that were supposed to be able to be, watching me when I'm with my son.
Mhm.
And she has not provided that. But the day Sunday when I'm supposed to see my son works for her schedule, but it takes a day off of my paycheck as well. I'm willing to see my son any day that possible. But if she's saying that Sunday is the only time that we can make that happen, I'm still having to take time off of work and still make payments for the visitation, not even the full 4 hours that I'm allotted a week, but I only get 2 and I have to pay for them. That's hard to pay. What was that? $340 a month to see my son for 4 hours. If she was really concerned about payments or any concerns about scheduling, she would not try to make it so that I can't attend all my days at work.
So
and also on that.
Okay, so let me ask this, and sometimes I feel a little bit more like a mediator than any sort of judicial officer, but my goal really is to help you all work through a contentious situation for the best interest of your child, okay? So in that regard, right now, so we understand Ms. Kamba has fully admitted that there were some scheduling issues with her work, in part probably due to the fact that she hasn't had child support money coming in because of this other mistake that's happening between your employer and DSHS. So I take that into account. But sitting here today now, do you all have a schedule that works for RF?
No.
Yes. I'm available on Sundays and Gabriel. It's based off of Gabriel's schedule due to Gabriel going to school now.
And Mr. Kamba, you're saying Sundays don't work for you. Is that correct?
That is correct, Your Honor. They do not work for me.
So what would work, taking into account that your son is in school now?
So that I could have my evenings with them. I would be after school on my days off.
But I don't know, do they offer the services at that?
They do, but I can't do evenings due to me having a second job because I'm not getting this child support, and I don't get off until 6, and then she will not have him be there past 7:30. So then he loses even more time. And that's why I've rearranged my whole schedule and gave them all of Sunday.
Okay. And Mr. Kamba, what is it about Sunday that you can't rearrange your schedule for?
Well, I have rearranged it for, and my employer is not happy with me not being able to work Sundays, which is one of the reasons that I was hired on with them.
Okay.
And like I said, I have evenings off from 7 and, after 7, but that's a bit late for my son. So on the days that I could have them during the week, I would request the whole day off from work so that I can dedicate that day to my son.
So here's my thought. So Ms. Kamba, once child support, whatever's happening with child support gets resolved, will your schedule free up where you don't have to have that second job in place?
That would actually have to be like if we can make sure it's coming in, because Mr. Kamba has a record, right? So I don't know how long that's going to take, but if it comes in.
She likes to bring this up all the time.
Mr. Kamba, please don't talk over. I'm going to come to you next. Don't worry, you'll get a chance to respond.
But he has a record of not paying child support. I've paid for his other kids before. So if he can continue to make payments regularly, then yeah, my schedule would free up and I wouldn't have to have a second job. But at this time, I can't rearrange it anymore because I'm supporting this kid and not getting child support.
Right.
And Gabriel going to school and having activities on Saturday that Mr. Kamba is not allowed a part of because of the no contact order. Sunday is the only day that works for Gabriel.
Mr. Kamba, what did you want to say? And then I'm going to wrap this up. We're already about 15 minutes over docket ending.
Well, I want to know when it is that I get my unsupervised visits with my son, because I should be having supervised visits where I don't have to pay for them, which she was supposed to provide a list of people. She never did.
Yes,
And
I
I
did.
want to know when phase
Yeah.
phase 2 starts.
Yeah, now, Mr. Kemba, you're bringing in, all you have put in front of me is a contempt request based on prior missed visitation. You have not put in front of me any request to do any sort of future scheduling or change to visitation scheduling. So what I'm going to do is set you both on both contempt issues. We'll set over to September 27th. I'm just being handed okay, thank you. I would first, I think we need to take this in steps. We first need to get the child support money that is owed and ordered to Ms. Kamba. So we need to figure out where that disconnect is occurring. Once that money comes in, then I think we can have a rational conversation about realistically what can visitation and reunification look like if Ms. Kamba doesn't have to have that second job. But I'll say, if both parties come back to me and say, well, because of my work, there's no day that we can both agree on, then I'm going to have to order a day, unfortunately, and it's going to put someone in a bind. So I'm imploring you in the next 2 weeks before we come back together to perhaps work on what that schedule could look like, taking into account the best interest of the child. Is that understood?
Yes.
Okay. So at this point,
No,
hold
I'd
on.
have no way of contacting her.
That's fine. What I'm saying is you're hearing what she is saying here today about her schedule and Gabriel's schedule because of school. So perhaps it's a conversation you need to have with your employer about what you could make work. The more reunification counseling that occurs, the more likely it is that the unsupervised visits occur. So I want you both to come back on September 27th with some sort of better indications to me on how to make this work for Gabriel, not just for the two of you. But I think before we even get to that point, Ms. Kamba needs to have the child support money coming in. So let's get that issue fixed and addressed. I'll see you both back on the 27th, and I'll reserve ruling on both of your cross contempt motions to that date when we have more information, okay?
Okay, so just keep doing what we're doing with the visitation as it is?
As it is right now, yes. Okay, so September 27th, 9 a.m. Mr. Kamba, if you also want to reach out to your payroll department to see if perhaps they're sending it to the wrong place, that might be helpful because based on the pay stub you submitted, they're clearly deducting it like they're supposed to. So maybe check in with them as well, okay?
Yeah, they've been taking it out, and one of the payments did go through. Like I said, with my child support.
The problem is it's not, DSHS isn't seeing it. So I would hit this on all ends.
You would see it.
Yeah, the more that you get involved in this process, it's much less likely there's going to be any sort of contempt on this issue because clearly your employer seems to be doing what they're supposed to be doing, but I would check with them to make sure it's getting to the right place, okay?
Yes, of course, Your Honor.
All right, we'll see you back in 2 weeks. All right, thank you both.
Thank you, Your Honor.
Thank you.